Continuing Appendix A to Part 2 of the Nevada Contractors Board Licensing Law, Chapter 624, regarding the State Contractors Board, picking up at NRS 624.190, action by District Court to compel attendance of witness or production of records, books, or papers. 1. The District Court in and for the county in which any hearing, investigation, or other proceedings is held by the board may compel the attendance of witnesses, the giving of testimony, and the production of records, books, and papers as required by any subpoena issued by the board or the executive officer. 2. In case of the refusal of any witness to attend or testify or produce any items required by the subpoena, the board may report to the district court in and for the county in which the hearing, investigation, or other proceedings will be held by petition setting forth that A. Due notice has been given of the time and place of attendance of the witness or the production of the records, books, or papers. B. The witness has been subpoenaed in the manner prescribed in this chapter. And C. The witness has failed and refused to attend or produce the items required by subpoena before the board in the cause or proceeding named in the subpoena, or has refused to answer questions propounded to him or her in the course of the hearing, investigation, or other proceeding. E. And ask an order of the court compelling the witness to attend and testify or produce the records, books, or papers before the board. 3. The court, upon petition of the board, shall enter an order directing the witness to appear before the court at a time and place to be fixed by the court in the order, the time to be not more than 10 days after the date of the order, and then and there show cause why the witness has not attended or testified or produced the records, books, or papers before the board. A certified copy of the order must be served upon the witness. 4. If it appears to the court that the subpoena was regularly issued by the board or the executive officer, the court shall thereupon enter an order that the witness appear before the board at the time and place fixed in order and testify or produce the required records, books, or papers. Upon failure to obey the order, the witness must be dealt with as for contempt of court. References: NRS 624.200. Deposition of witness. The board may, in any hearing, investigation, or other proceedings before it cause the deposition of witnesses residing within or without the state to be taken in the manner prescribed by the Nevada Rules of Civil Procedure for like depositions in civil actions in the district courts of this state, and to that end may compel the attendance of witnesses and the production of records, books, or papers. References: NRS 624.210. Right of property to compel attendance of witness or taking of deposition. Any party to any hearing, investigation, or other proceeding before the board has the right to the attendance of witnesses in his or her behalf at the hearing, investigation, or other proceedings upon deposition as set forth in this chapter upon making a request, therefore, to the board and designating the person sought to be subpoenaed. References: NRS 624.212. Cease and desist order for unlicensed activity, issuance, service, actions that board is authorized or requested to take after issuance, petition to lift or alter order, authority of board to consider order when considering application for license, fine imposed by court for violation of order. 1. The executive officer on behalf of the board shall issue an order to cease and desist to any person, A, acting as a contractor, including without limitation, commencing work as a contractor, or B, submitting a bid on a job situated in this state, E, without a valid license issued pursuant to this chapter. The order must be served personally or by certified mail and is effective upon receipt. For the purposes of this section, a person shall be deemed to have a valid license if the person has an active license and is performing work in conformity with the requirements of subsection 4 of NRS 624.220. 2. After confirming that the cease and desist order has been received by the person to whom it was issued, the board shall return to the job site or take any other action required to confirm the terms of the cease and desist order have been complied with. The person to whom the cease and desist order was issued may, while in the course of stopping work on the job, take any necessary action within 48 hours after receiving the cease and desist order to protect the public, the project, any other contractors, laborers, and equipment on the site, and to limit the loss of any perishable goods. 3. After issuing a cease and desist order, the board shall, A, for the first violation, which does not invoice theft or fraud, issue an administrative citation pursuant to NRS 624.341 and impose an administrative fine against the person in accordance with NRS 624.710, in addition to any reasonable investigatory fees and costs. B, for a second or subsequent violation, or for any first violation involving theft or fraud, take any or all of the following actions. Issue an administrative citation pursuant to NRS 624.341 and impose an administrative fine against the person in accordance with NRS 624.710, in addition to any reasonable investigatory fees and costs. 2. Report the violation of the provisions of this chapter for possible criminal prosecution pursuant to NRS 624.700. If the violation is prosecuted, the board shall provide any reasonable assistance in the prosecution. 4. After issuing a cease and desist order, in addition to the actions required by subsection 3, the board may A, require the person to submit a bona fide application for the issuance of a license pursuant to this chapter within a reasonable period established by the board. B, if the board determines that any term of the cease and desist order has not been complied with and no exception apply for injunctive relief pursuant to the Nevada Rules of Civil Procedure to enjoin the person to whom the cease and desist order was issued from continuing to violate the cease and desist order in any county in which the person may be found. If such an action is filed, irreparable injury is presumed and the likelihood of success on the merits may be established by showing that on the date the cease and desist order was issued, the person did not hold a valid license issued pursuant to this chapter and had bid for or undertaken work for which such a license is required. 5. When assessing an administrative fine pursuant to this section, the board may, A, require the person to whom the cease and desist order was issued to remedy any loss or damage caused by the unlicensed activity for which the order was issued, including, without limitation, the disgorgement of any amount of money collected from the owner of the project that was not for material delivered to the job site and that has not been damaged or altered by the person. B, reduce or stay any administrative fine imposed pursuant to subsection 3 pending completion by the person of the program of training or an examination required by the board. Or C, reduce or stay any administrative fine imposed pursuant to subsection 3 if the person obtains a valid license issued pursuant to this chapter. 6. When imposing an administrative fine pursuant to this section, the board shall impose a maximum administrative fine established pursuant to this chapter for the unlicensed activity if more than one of the following circumstances exist. A, the person has previously committed the same or a similar violation as the violation for which the administrative fine is imposed. B, the unlicensed activity involves more than one trade or craft. C, the unlicensed activity resulted in harm to any person or property. D, the unlicensed activity involved an elderly person or a person with a diagnosed physical or mental condition, disability. Or E, the unlicensed activity was for a project having a contract value in excess of $50,000. 7. Within 15 business days after receiving a cease and desist order, the person against whom the order was issued may petition the board in writing to lift or alter the order. The petition may assert: A, as an absolute defense, 1, licensure of the person pursuant to this chapter; 2, any applicable exception to the licensure set forth in NRS 624.031; or 3, misidentification of the person. B, as a partial defense, 1, overbreadth of any term of the cease and desist order; 2, vagueness or ambiguity of any term of the cease and desist order. 3. Consideration of any necessary action taken by the person to protect the public, the project, any other contractors, laborers, and any equipment on the job site, and to limit any loss of perishable goods. Or 4. Any other deficiency in the terms of the cease and desist order. 8. After considering any assertion made in petition pursuant to A, paragraph A of subsection 7, the board shall, if facts are established to the satisfaction of the board to support the absolute defense asserted in the petition, vacate the cease and desist order of any portion thereof. B, paragraph B of subsection 7. The board shall, if facts are established to the satisfaction of the board to support the partial defense asserted in the petition, reasonably clarify any terms of the cease and desist order requested by the petitioner. 9. When considering an application for the issuance of a license pursuant to this chapter, the board may consider A, any cease and desist order issued against the applicant. B, compliance by the applicant with any cease and desist order issued against him or her. C, any criminal conviction of the applicant for failure to comply with any cease and desist order. Or D, the payment by the applicant of any criminal or administrative fine and any administrative fee or cost imposed against the applicant. 10. If the court finds that a person violated an order issued pursuant to subsection 1 without an established absolute defense set forth in paragraph A of subsection 7, it shall impose a fine of not less than $250, nor more than $1,000 for each violation of this order. References. Persons authorized to perform certain types of work for contractor. NRS 624.213. Persons authorized to perform work requiring a license and work not requiring a license for a contractor. 1. A contractor may perform work that requires a contractor's license, A, himself, herself, or itself, or B, by or through an employee or employees of the contractor or of another contractor. 2. Work that does not require a contractor's license may be performed for and under the direction and control of a contractor by a person who is A, described in subsection 1, or B, employed by a private employment agency that is licensed by the Labor Commissioner pursuant to NRS 611.045. 3. As used in subsection 1, employee has the meaning ascribed to it in subsection 6 of NRS 624.020. Classifications. NRS 624.215. Contracting business. 1. For the purpose of classification, the contracting business includes the following branches: A, general engineering contracting; B, general building contracting; C, specialty contracting. E, general engineering contracting and general building contracting are mutually exclusive branches. 2. A general engineering contractor is a contractor whose principal contracting business is in connection with fixed works, including irrigation, drainage, water supply, water power, flood control, harbors, railroads, highways, tunnels, airports and airways, sewers and sewage disposal systems, bridges, inland waterways, pipelines for transmission of petroleum and other liquid or gaseous substances, refineries, chemical plants, and industrial plants requiring a specialized engineering knowledge and skill, power plants, piers, and foundations and structures of work incidental thereto. 3. Except as otherwise provided in subsection 5 and 6, a general building contractor is a contractor whose principal contracting business is in connection with the construction or remodeling of buildings or structures for the support, shelter, and enclosure of persons, animals, chattels, or movable property of any kind, requiring in their construction the use of more than 2 unrelated building trades or crafts, upon which he or she is a prime contractor, and where the contractor or he or she is a prime contractor where the construction or remodeling of a building is a primary purpose. Unless he or she holds the appropriate specialty license, a general building contractor may only contract to perform specialty contracting if he or she is a prime contractor on a project. except as otherwise provided in subsection 4 of NRS 624.220. A general building contractor shall not perform specialty contracting in plumbing, electrical, refrigeration, air conditioning, or fire protection without a license for the specialty. A person who is licensed pursuant to Chapter 489 of NRS and who exclusively constructs or repairs mobile homes, manufactured homes, or commercial coaches is not a general building contractor. 4. A specialty contractor is a contractor whose operations as such are the performance of construction work requiring special skill and whose principal contracting business involves the use of specialized building trades or crafts. 5. A general engineering contractor, when acting as a prime contractor, may hire not more than one general building contractor to provide any work, materials, or equipment as specified in subsection 3 on a single construction project. 6. A general building contractor may contract to provide management and counseling service on a construction project for a professional fee. A general building contractor who has contracted to provide management and counseling services, A, must have an active license in the same classification and subclassification that are required to be held by the prime contractor on the project. B, may not hire more than one general building contractor to provide any work, materials, or equipment as specified in subsection 3 on a single construction project. 7. A single construction project must be limited to not more than one general building contractor who provides management and counseling services for a professional fee, and not more than one general building contractor who provides any work, materials, or equipment as specified in subsection 3. 8. Except as otherwise provided in this subsection, each construction project must have one, but not more than one, prime contractor who is a licensed contractor and is responsible for the work, material, and equipment for the construction project. A construction project is not required to have a prime contractor if the work for the construction project or person providing the work for the construction project is exempt pursuant to NRS 624.031. NRS 624.031. Applicability of chapter exemptions. The provisions of this chapter do not apply to 1. Work performed exclusively by an authorized representative of the United States government, the state of Nevada, or an incorporated city, county, irrigation district, reclamation district, or other municipal or political corporation or subdivision of this state, as others reference. 9. The section does not prevent the board from establishing, broadening, limiting, or otherwise effectuating classification in a manner consistent with established custom, usage, and procedure found in the building trades. The board is specifically prohibited from establishing classifications in such a manner as to determine or limit craft jurisdictions. 10. As used in this section, prime contractor means A. A general engineering contractor who enters into an oral or written agreement with an owner of a construction project or an agent of an owner to provide any work, materials, or equipment for which the general engineering contractor is licensed. B. A general building contractor who enters into an oral or written agreement with an owner of a construction project or an agent of an owner to provide any work, materials, or equipment for which the general building contractor is licensed. C. A general engineering contractor and general building contractor who enter into an oral or written agreement with an owner of a construction project or an agent of an owner to provide any work, materials, or equipment for which the general engineering contractor and general building contractor are licensed. Or D. A specialty contractor who enters into an oral or written agreement with an owner of a construction project or an agent of an owner to provide 1. Any work, materials, or equipment for which the specialty contractor is licensed, and 2. Any other work which is incidental and supplemental thereto. Referenced. NRS 624.218. Classifications 4. Classification for persons who construct or improve video service networks. Regulations. 1. The board shall adopt, by regulation, a classification of licensing for persons who construct or improve video service networks, except as otherwise provided in subsection 2. A person who engages in such construction, alteration, or improvement must be licensed in this classification and may not be required to be licensed in any other classification. 2. The licensing requirements adopted pursuant to subsection 1 do not apply to a person who is engaged solely in the alteration or repair of antenna used by a community antenna television system. 3. As used in this section, video service network has the meaning ascribed to it in NRS 711.145 references. NRS 624.220 Contractors. Monetary limit on license regulations. 1. The board shall adopt regulations necessary to effect the classification and subclassification of contractors in a manner consistent with established usage and procedure as found in the construction business, and may limit the field and scope of the operations of a licensed contractor to those in which the contractor is classified and qualified to engage as defined by NRS 624.215 and the regulations of the board. 2. The board shall limit the field and scope of the operations of a licensed contractor by establishing a monetary limit on a contractor's license, and the limit must be the maximum contract a licensed contractor may undertake on one or more construction contracts on a single construction site or subdivision site for a single client. The board may take any other action designed to limit the field and scope of operations of a contractor as may be necessary to protect the health and safety and general welfare of the public. The limit must be determined after considerations of the factors set forth in NRS 624.260 to 624.265, inclusive. 3. A licensed contractor may request that the board increase the monetary limit on his or her license either on a permanent basis or for a single construction project. A request submitted to the board pursuant to this subsection must be in writing on a form prescribed by the board and accompanied by such supporting documentation as the board may require. Requests submitted pursuant to this subsection for a single construction project must be submitted to the board at least 5 working days before the date on which the licensed contractor intends to submit a bid for the project and must be approved by the board before submission of a bid by the contractor for the project. 4. Subject to the provision of regulations adopted pursuant to subsection 5. Nothing contained in this section prohibits a specialty contractor from taking and executing a contract involving the use of 2 or more crafts or trades if the performance of the work in the crafts or trades other than in which the specialty contractor is licensed is incidental and supplemental to the performance of work in the craft for which the specialty contractor is licensed, or B, except as otherwise provided in this paragraph, a licensed contractor from performing the work of a type for which the contractor does not have a license in the applicable classification or subclassification if the value of the work is less than $1,000, including labor and materials, and the work does not require a permit. A licensed contractor shall not perform work of a type for which the contractor does not have a license in the applicable classification or subclassification if the work is of a type performed by a plumbing, electrical, refrigeration, or air conditioning contractor. 5. The board shall adopt regulations establishing a specific limit on the amount of asbestos that a licensed contractor with a license that is not classified for the abatement or removal of asbestos may abate or remove pursuant to subsection 4. References. NRS 624.240. Issuance of licenses. Use of examinations to investigate, classify, and qualify applicants' additional qualifications for master license, transitory provision. Under reasonable regulations adopted by the board may investigate, classify, and qualify applicants for the contractor's licenses by written or oral examinations, or both, and may issue contractor's licenses to qualified applicants The examinations may, in the discretion of the board, be given in specific classifications only. 2. If a natural person passes the technical examination given by the board on or after July 1st, 1985, to qualify for a classification established pursuant to this chapter, demonstrates to the board the degree of experience and knowledge required in the regulations of the board and is granted a license, the person is qualified for a master's license if issued by any political subdivision in the classification for which the examination was given. If the examination required the person to demonstrate his or her knowledge and ability to A. utilize and understand, B. direct and supervise work in compliance with, and C. perform and apply any calculations required to ensure that work performed is in compliance with E. the applicable code, standards, and regulations. 3. If a natural person qualified for a license before July 1st, 1985, in accordance with NRS 624.260, in a trade for which a master's license is required by any political subdivision, and if the license is active on or after July 1st, 1985, and if the person so qualified wishes to obtain a master's license, the person must pass either the appropriate examination given by the board on or after July 1st, 1985, in accordance with NRS 624.260, and the regulations of the board, or the examination given by the political subdivision in the trade for which the master's license is required. References. NRS 624.241, continuing with licenses, program for issuance of license in expedited manner. The board may establish a program for the issuance of a license in an expedited manner. The board shall not allow the operation of the program for the issuances of the license in an expedited manner to affect adversely the amount of time the board requires to issue any other contractor's license. Reference. NRS 624.245. Temporary prohibition of certain violators from taking examination. The board may prohibit a person who has been convicted of violating NRS 624.700 or 624.740 from taking a written or oral examination for a contractor's license for a period of not more than 6 months from the date of conviction. References. NRS 624.250, application for issuance or renewal of license. Contents, fees and assessments, contributions to construction education account. 1. To obtain or renew a license, an applicant must submit to the board an application in writing containing A. the statement that the applicant desires the issuance of a license under the terms of this chapter. B. Street address or other physical location of the applicant's place of business. C. The name of a person physically located in the state for service of process on the applicant. D. The street address or other physical location in this state, and if different, the mailing address for service of process on the applicant. E. Except as otherwise provided in paragraph F or G, the names and physical and mailing addresses of any owners, partners, officers, directors, members, and managerial personnel of the applicant. F. If the applicant is a corporation, the names and physical and mailing addresses of the president, secretary, treasurer, and any officers responsible for contracting activities in this state, any officers responsible for renewing the license of the applicant, any persons used by the applicant to qualify pursuant to NRS 624.260, and any other persons required by the board. G. If the applicant is a limited liability company, the names and physical and mailing addresses of any managers or members with managing authority, any managers or members responsible for contracting activities in this state, any managers or members responsible for renewing the license of the applicant, any persons used by the applicant to qualify pursuant to NRS 624.260, and any persons required by the board. NRS 624.260, applicant and licensee required to demonstrate experience, knowledge, and financial responsibility qualifications concerning experience and knowledge limitations on qualifications of natural person. H. Any information requested by the board to ascertain the background, financial responsibility, experience, knowledge, and qualifications of the applicant. I. All information required to complete the application. 2. The application must be A. Made on a form prescribed by the board in accordance with the rules and regulations adopted by the board. B. Accompanied by the application fee fixed by this chapter. 3. The board shall include on an application form for the issuance or renewal of a license a method for allowing an applicant to make a monetary contribution to the construction education account created pursuant to NRS 624.580. The application form must state in a clear and conspicuous manner that a contribution to the construction education account is voluntary and is in addition to any fees required for licensure. If the board receives a contribution from an applicant, the board shall deposit the contribution with the state treasurer for credit to the construction education account. 4. Before issuing a license to any applicant, the board shall require an applicant to pay the license fees fixed by this chapter, and if applicable, any assessment required pursuant to NRS 624.470. References. NRS 624.253, application for one or more classifications. Additional application fee for license may be required. 1. A licensee may make application for classification and be classified in one or more classifications if the licensee meets the qualifications prescribed by the board for such additional classifications. An additional application and license fee may be charged for qualifying or classifying a licensee in additional classifications. NRS 624.254. Issuance or renewal of license under name likely to result in confusion or mistake prohibited. No license may be issued or renewed by the board under a name which is the same as the name of another licensee. 2. So resembles the name of another licensee that the board determines that is likely to result in confusion or mistake. Or 3. The board determines is likely to mislead the general public. References. NRS 624.2545, denial of application for issuance of or renewal of license. Notice, request for hearing, delegation of authority to hearing officer, regulations. 1. If the board denies an application for issuance of renewal of a license pursuant to this chapter, the board shall send forth by certified mail, return receipt requested, written notice of the denial to the most current address of the applicant set forth in the records of the board. 2. A notice of denial must include, without limitation, a statement which explains that the applicant has a right to a hearing before the board if the applicant submits a written request for such hearing to the board within 60 days after the notice of denial is sent to the address of the applicant pursuant to this section. 3. If an applicant who receives a notice of denial pursuant to this section desires to have the denial reviewed at a hearing before the board, the applicant must submit a written request for a hearing before the board concerning the denial within 60 days after the notice of denial is sent to the applicant's address. If an applicant does not submit notice in accordance with this subsection, the applicant's right to a hearing shall be deemed to be waived. 4. Except as otherwise provided in this subsection, if the board receives notice from an applicant pursuant to subsection 3, the board shall hold a hearing on the decision to deny the application of the applicant within 90 days after the date the board receives the notice pursuant to subsection 3. If an applicant requests a continuance and the board grants this continuance, the hearing required pursuant to this subsection may be held more than 90 days after the date the board receives notice pursuant to subsection 3. 5. The board may delegate to a hearing officer or panel its authority to hold a hearing concerning the denial of an application pursuant to this section. The board shall adopt regulations setting forth the qualifications for a hearing officer. References. NRS 624.256, proof of industrial insurance, notification of fraud control unit for industrial insurance of failure to obtain industrial insurance. disciplinary action. Penalty for failure to pay contributions to an employment compensation fund. 1. Before granting an original or renewal of a contractor's license to any applicant, the board shall require that the applicant submit to the board A. proof of industrial insurance and insurance for occupational diseases which covers the applicant's employees. B. A copy of the applicant's certificate of qualification as a self-insured employer which was issued by the Commissioner of Insurance. C. If the applicant is a member of an association of self-insured public or private employers, a copy of the certificate issued to the association by the Commissioner of Insurance, or D, an affidavit signed by the applicant affirming that he or she is not subject to the provisions of Chapter 616A to 616D, inclusive, or Chapter 617 of NRS because the applicant, 1, has no employees, 2, is not or does not intend to be a subcontractor for a principal contractor, and 3, has not or does not intend to submit a bid on a job for a principal contractor or subcontractor. 2, the board shall notify the Fraud Control Unit for industrial insurance established pursuant to NRS 228.420. Whenever the board learns that an applicant or holder of a contractor's license has engaged in business as or acted in the capacity of a contractor within the state without having obtained or maintained industrial insurance or insurance for occupational diseases in violation of the provisions of Chapter 616A to 617, inclusive of NRS. 3. Failure by an applicant or holder of a contractor's license to file or maintain in full force and the required industrial insurance and insurance for occupational diseases constitutes cause for the board to deny, revoke, suspend, refuse to renew, or otherwise discipline the person unless the person has complied with the provisions set forth in paragraph D of subsection 1. 4. As soon as practical, but not more than 3 business days after receiving notice from the Department of Employment, Training, and Rehabilitation pursuant to NRS 612.642, that a judgment has been obtained against a contractor for failure to pay contributions to the Unemployment Compensation Fund or from the Division of Industrial Relations of the Department of Business and Industrial and Industry pursuant to NRS 616B.630, that a contractor is not in full compliance with the requirements of Chapter 616A to 617, inclusive of NRS, the board shall notify the contractor by mail at the last known address of the contractor as it appears in the records of the board that the board will suspend the license of the contractor if the contractor does not furnish proof within 30 days after the date of notice sent by the board that the contractor has satisfied the judgment reported to the board pursuant to NRS 612.642 or is in full compliance with the requirements of Chapter 616A to 617, inclusive of NRS. 5. If the contractor fails to furnish proof within 30 days after the date of notice sent by the board pursuant to subsection 4 that the contractor has satisfied the judgment reported to the board pursuant to NRS 612.642 or is in full compliance with the requirements of Chapter 616A to 617, inclusive of NRS, the board shall, as soon as practical, but not more than 3 business days after the expiration of the 30-day period, for a first offense, A. Summarily suspend the license of a contractor without further notice pursuant to subsection 4 of NRS 624.291, and B. Require the contractor to submit to the board a list of all projects for which the contractor has unfulfilled contractual obligations where the contract was entered into on or before the date of the notice sent by the board pursuant to subsection 4. 6. If a contractor's license is suspended pursuant to paragraph A of subsection 5, A, the suspension must continue until the contractor furnishes proof of that the contractor has satisfied the judgment reported to the board pursuant to NRS 612.642 or is in full compliance with the requirements of Chapter 616A to 617, inclusive of NRS. B. During the term of the suspension, the contractor shall not submit any bids for any new work or begin work on any project not described in the list submitted to the board pursuant to paragraph B of the subsection 5. And C, the board shall notify 1. The office of the Labor Commissioner, which shall, as soon as practical, but not more than 3 business days after receipt of the notice, add the name of the contractor to the list of contractors who are disqualified to bid on public works, and 2. The State Public Works Board, which shall, as soon as practical, but not more than 3 business days after the receipt of the notice, add the name of the contractor to the list of contractors who are not pre-qualified to bid on public works. 7. If the name of a contractor is added to a list pursuant to paragraph C of subsection 6, the office of the Labor Commissioner or the State Public Works Board, as applicable, shall remove the name from the list when notified by the board that the suspension has been lifted pursuant to paragraph A of subsection 6. 8. If the board finds that the contractor has failed to provide a complete list of projects in accordance with paragraph B of subsection 5, or has violated paragraph B of subsection 6, the board shall, A, for a first offense, suspend the contractor's license for an additional 12 months after the contractor furnishes the proof described in paragraph A of subsection 6, and B, for a second or subsequent offense, conduct a hearing pursuant to NRS 624.291, and if it is determined at the hearing that a second or subsequent offense has been committed, revoke the contractor's license. 9. If a contractor for whom the suspension of a contractor's license has been lifted after providing the proof required pursuant to paragraph A of subsection 6 receives notice from the board pursuant to subsection 4 within 5 years after the date of reinstatement, and the contractor fails to furnish proof within 30 days after the date of the notice sent by the board that the contractor has satisfied the judgment reported to the board pursuant to NRS 612.642, or is in full compliance with the requirements of Chapter 616A to 617, inclusive of NRS, the board shall conduct a hearing pursuant to NRS 624.291, and if it is determined at the hearing that a second or subsequent offense had been committed within a 5-year period, revoke the contractor's license. References. Thank you for reviewing Appendix A Part 2. We got from 624.190 through 624.259, and we will continue to Part 3 after a short break. We will continue in licenses. I hope you are finding benefit in the reading of Appendix A of the Nevada Contractors Board Licensing Law, Chapter 624.